Pursuant to Chapter 551, Title 5 of the Texas Government Code, Texas Open Meetings Act, notice is given that the City Commission of the City of Brownsville, Texas, in accordance with Article 5, Section 12 of the Charter of said city, will convene a regular meeting on Tuesday, October 5th, 2021, at 5 p.m. at the Brownsville Public Library Main Branch Meeting Room, located at 2600 Central Boulevard, Brownsville, Texas. Pursuant to Section 551.127 Texas Government Code, one or more commissioners or city employees may attend this meeting remotely using video conferencing technology. The video and audio feed of the video conferencing equipment can be viewed and heard by the public at the address posted above as the location of the meeting. Members of the public, employees, and the city commission may join via the WebEx teleconference meeting link provided at the Brownsville Agenda Center. This notice and meeting agenda are posted online at the City of Brownsville Agenda Center. The members of the public wishing to participate in the meeting hosted through WebEx teleconference can join at the numbers provided on the agenda. Members of the public who submitted a public comment form will be permitted to offer public comments as provided by the agenda and as permitted by the presiding officer during the meeting. A recording of the meeting will be made and will be available to the public in accordance with the Open Meetings Act. Mayor, I show that we have quorum and all members of the city commission in attendance in person.
All right, well, thank you, Laurie. Being that we have a quorum, let's go ahead and get started. I'll call the meeting to order. Thank you.
Okay, it's 5:03 p.m. And our next item is the Pledge of Allegiance to the United States and Texas flag.
Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Our next item is the invocation.
Pastor, welcome.
Well, thank you. Thank you. Let's pray. Father God, we thank you for the many blessings we have in Brownsville. We thank you for the things that we don't normally thank you for. Help us to remember to be grateful. And Father God, right now we have people in our city who have lost a lot through flooding, and we ask you to bless them, lead and guide them in putting their lives back together. And Lord, I ask you to lead and guide the rest of us in what help we may be able to provide them, what resources we may be able to provide them, and lead and guide our city officials and staff as far as avoiding future flooding. Lord, we ask you to release truth in the nation from Washington to Austin to right here in Brownsville. And Lord God, for tonight, we ask you to anoint our mayor, each city commissioner, and everybody presenting anything for the very best for the city of Brownsville. We ask all of these things in your precious name, Jesus Christ. Amen. Amen.
Thank you, Pastor.
Our next item is proclamation. The first or the only proclamation that is the proclamation designating the month of October 2021 as National Domestic Violence Awareness and Prevention Month in the city of Brownsville, sponsored by Commissioner Gowan and Commissioner Gallant.
Do you want to read it, Dr. Gowan? Okay. Okay. Thank you. This is a proclamation, Commission of Brownsville, Texas, designating the month of October 2021 as National Domestic Violence Awareness and Prevention Month in the city of Brownsville. Whereas the first Domestic Violence Month was observed in October 1987, the same year that saw the initiation of the first National Domestic Violence Toll-Free Hotline. And whereas in 1989, Congress designated the month of October as National Domestic Violence Awareness Month. And whereas domestic violence is more than the occasional family dispute. According to the Bureau of Justice, statistics from 2003 to 2012, domestic violence accounts for 1% of all violent crimes. In addition, in 2013 in Texas, there were 76,704 reported victims of abuse by a current or former spouse. And whereas domestic violence across all ages, racial, ethnic, sexual preference, spiritual, and socioeconomic boundaries, and whereas an estimated 1.2 million women were victims of physical assault by an intimate partner each year. In 2019, according to the Texas Uniform Crime Reporting, UCR, law enforcement officers in Texas responded to 198,899 incidents of family violence, of which 151 women and 34 men were killed. 185 Texans were killed by their intimate partners in 2019. In addition, these domestic violence homicide perpetrators also killed 20 family members, friends, and bystanders. And whereas women are not the only targets and young children and the elderly only are counted among the victims, as a result, sadly, emotional scars are often permanent. And whereas a coalition of organizations has emerged to directly confront the crisis, law enforcement officials, those involved with shelters and hotline services, healthcare providers, the clergy, and other concerned citizens are helping in the efforts to end domestic violence. Let's recognize the compassion and dedication of these volunteers and professionals, applaud their efforts, and increase public understanding of this important problem. Now, therefore, we, the members of the City Commission of the City of Brownsville, Texas, by virtue of the authority vested by the Charter of said city, do hereby declare the month of October 2021 as National Domestic Violence Awareness and Prevention Month in the City of Brownsville, and urge all residents to show their support during the month of October 2021, showing compassion to the victims and honoring the organizations and the efforts made to overcome domestic violence and to increase public awareness and enhance prevention efforts toward this important national problem. Done on this, the 5th day of October 2021, signed by the Mayor and the City Commission.
Thank you, Commissioner.
There will be an event towards the end of this month, I think it's like the last week, where it'll be sponsored by the family, sorry, I just blanked out on their name, the shelter.
Of Texas?
No, family, oh geez, what's their name?
Friendship of Women?
Yes, thank you, Friendship of Women. And promotoras, and to get out the word. I know that with the pandemic ending in the last year, there was an increased rate of domestic violence. A lot of it went unreported. And so hopefully now that we're slowly going back to normal, it'll be a little bit better.
And Commissioner, I believe Yvonne Lopez was on, I don't know if she's still on there. She was, who had requested the proclamation.
I do see her name. There you go. Welcome, Yvonne. Would you like to say something?
Hi, thank you. I just want to thank you for the recognition and really bringing this issue to the forefront. This is so important to bring about not just every month, but all year long because of the impact that it has on our community, our family, our friends. So thank you. Thank you for sharing the platform. Thank you for starting the conversation. And we just really appreciate the support here at Friendship of Women.
And it isn't just adult women, it's also, and I'm glad that we're seeing more and more young people talk about it at high school level so that it becomes easier to report and easier to identify.
Yes, correct. Yeah, we actually this year we created a youth advisory council, and it is with young people in high school that are creating movements within their own communities and social media. So really just bringing forward these topics and how we can help prevent them, as well as create healthy communities and healthy relationships for men, women, and children.
So thank you for all you do, because it is important work, very important.
Thank you. Thank you so much.
Thank you.
Our next item is public comment period. And we received one public comment form from Victoria Garcia. Victoria, are you present?
It appears.
Okay.
Okay. All right, then we'll move on to our next item, work sessions. Item 1, Chapter 38, Ethics, Ordinance, and Proposed Amendments, City Attorney.
Good evening, Mayor and Commissioners. I anticipate that we're going to have plenty of discussion about Chapter 38 today. To be efficient and productive, I've presented what I would call like 3 categories of proposed amendments. The first being more clarified and detailed process in appointing outside counsel for situations where there's a conflict of interest, where one of the city commissioners might be a party to a complaint. Also, the question of subpoena power for the EAC, that's also been a discussion as well. And then application of Chapter 38 to economic incentives. And a little bit, I'm going to allow for the commission to actually decide whether it would like to address each of these recommendations today, or select one or a few today and then spread the rest out for other meetings, because I do realize that there can be a lot of discussion on any given one of these. I do want to provide some just high level comments before we get started. This item is going to be a high level discussion to provide myself and my team on a process and how to maybe draft these a little bit more specifically. And so we'll just kind of be talking about these principles and ideas from a high level perspective to give us direction on how to draft these and bring them at a subsequent city commission meeting. I hope that my job today will be to facilitate a productive and efficient discussion to draw a consensus among all 7 of our commissioners, and to, again, compile everybody's input into one cohesive document for proposed amendments coming in the future. And that I'm going to propose that to keep it orderly and efficient and respectful of everybody's time, I'd like to allow every commissioner to, as we go through these different amendments, to have appointed time to provide comments. And what I would like to do is to synthesize those. I'll be taking notes. I might ask for a little bit slower correspondence so I can take appropriate notes, but then share that summary with everybody and allow every commissioner one last chance to either respond or provide additional comments afterwards. As with any agenda item, I will keep the commission within the scope of this item, and just to set expectations and a productive path to resolving some of these deficiencies that we've been able to identify already. I want to outline the facts that actually brought these proposed amendments to the commission today. There are going to be 2 situations. One was the situation or the evidentiary hearing process with that involved Commissioner Cowan and your complaint. I believe the first 2 really addressed inefficiencies in that process. The second would be the recent application that was submitted before BCIC for an incentive grant project funded privately by the Musk Foundation. And again, this item is to address to identify the solutions to improving Chapter 38, to make sure that the commission's expectations are clear. This item is not to inquire into today whether there was any ethical or legal violations. And if there are any criminal or ethical complaints, I assure this commission that I will provide appropriate legal counsel, best executive session item. And with that, those are kind of my introductory comments, but I would like to offer it to the city commission. Do we want to tackle all 3 or just 1 or 2?
I mean, you mentioned one was legal counsel, the other is incentives, and what was the third one?
The subpoena power.
I mean, I think we should probably just go in order and then just
Okay.
give us your thoughts, and
Sure.
if any of us need to chime in.
Sure. Again, the space that we'll be interacting in today is the ethical space. Of course, legal standards are the minimum. And then, of course, your moral and personal guidelines, we're not going to touch those. Each person has those. But the ethical standards that we hope to clarify are those that impact the organization and a local community. And as we talk about amendments, I just wanted to have another prong of like introductory comments. As attorneys, we can really mess things up when we go back and try to change language. With words, there are consequences, right? And so we want to be careful and diligent and looking long-term as to what those changes communities and things, those changes will impact. So I actually, in preparing for today's meeting, came across this quote, says, long-range planning doesn't deal with future decisions, but with the future of present decisions. And I thought that was kind of an appropriate introduction into our discussion today. So the first one is to establish clear and neutral process for appointing independent outside counsel. And one of the things that happened in Commissioner Cowan's evidentiary hearing was there was a perceived conflict between the city attorney's office, who represented the EAC, and then a commissioner. And so I would see where appointing an attorney to represent, outside counsel to represent the commissioner's complaint at that point might even have some problems in itself, because you're kind of reacting to it. So what I propose is the city commission pre-selecting 4 attorneys, having a list, just as some of the departments have a rotating list that have been vetted and procured, but having a pre-selection of 4 attorneys that would be on a rotating list. 2 attorneys would be kind of reviewed every 2 years to provide continuity in case there are cases already existing that they would be working on. They would have full investigatory authority. They would provide the EAC with reports that included facts, findings, and conclusions to support whether there was a violation of Chapter 38 or not. And that would be used by EAC to actually support their own investigations. And you would have the advocacy element for the complainant in that sense. Any comments from the commission on that?
Sure. On this, as far as the selection of the attorneys, just having individuals submit some sort of application or request to be considered? Or were you intending that there were just going to be 4 names thrown out there? Because, I mean, obviously the 4 names could create some inequities possibly.
Right. Right. No, I would propose that it would be posted, have people the opportunity to apply. Again, check for conflicts within those applications, and then ultimately present a proposed list. More than 4, but I have like a priority of 4, and then maybe some alternates in case there's disagreement about any of those 4.
And then with these outside counsel, would that be to actually present the case to the committee? Because I know that that was an underlying issue and a major issue in this initial hearing that we had, or initial hearing that was had by the committee. And the presentation of the facts and the evidentiary hearing itself not being presented by counsel or not being really presented by anyone caused an issue.
Right.
Chapter 38 itself does talk about the city attorney being the attorney for this, and then the ability of outside counsel also to present if there's a conflict. So it's in there already. It's just a matter, like, what's not necessarily clear is how it's presented to the committee.
Right. And my recommendation is that it's submitted to the committee via report. Again, having full investigatory powers, that attorney will go and conduct witness interviews and record, through the requesting of records, and then compile a full report with his recommendation to the EAC, which they can consider and then have follow-up questions from there.
And would that be prior to, because there's a process also, it's kind of like a 2-step process where there's a determination whether or not there's merit to the complaint? Is this post?
This is post the merit.
Okay. Once the merit portion's been determined, then this comes.
That's correct.
Okay.
Question. So in the case of one commissioner or mayor making a complaint against another commissioner or mayor, how would it be determined who gets the city attorney and who gets one of these rotating attorneys? Or do they both get a rotating attorney?
So the complainant, they have the burden of establishing and submitting the information to the EAC. They're also authorized to bring in their own attorney. In this case, that complainant would be represented by the outside counsel. The person, there's already a right for the person being
Complained against.
to have their attorney, and that's kind of the process through a court system already.
So it might be the city attorney, the person making the complaint, but if there's a conflict of interest, it would be one of these four.
Yes,
Okay.
correct.
And the person being accused would theoretically have their own.
Their own attorney, and that already exists in chapter 38.
I understand.
But then, as Commissioner Gowan said, if it's, say, city commissioner versus city commissioner, then does the city really have to pay for two attorneys?
I'm not suggesting that. No, it would just be the complainant would have, essentially the prosecutorial role would come in through that outside legal counsel. The person being complained against, as their right, has an opportunity to hire their own, essentially defense counsel. But that would be on them. It would just be one attorney.
I have just a couple on this point in particular. I think it would be appropriate for us, because we don't want the lawyers who get selected for this, we don't want this to be a popularity contest. This is ethics. I think there should be a higher standard. I think when those four lawyers are chosen, it should be by a supermajority of the commission. I think that would be appropriate. And then I think we also need to look at, as we work on chapter 38, identifying what would constitute a conflict for any one of those attorneys. Because if they're next on the rotation, but they've got some type of conflict, we need to have that spelled out.
That might include an assertion of a complaint that there, or an assertion by the accused, so to speak, that there's a conflict, right?
But even if you identify, spell it out, as you say, Commissioner Dos Santos, as soon as you say these are the three things that could be conflict, there's going to be a fourth that comes up. So I would want the language to say, okay, these are the potential conflicts, but not limited to leave it open for something else that we didn't anticipate.
Absolutely. Now, with regard to full investigatory authority, as I understand that here, that's with regard to the council. Is that correct?
Sorry, just give me a second.
That's right.
What was that, Commissioner? Was something?
With regard to full investigatory authority, is that with regard to the outside counsel? Or is that with regard to the EAC?
My opinion, this is council.
This is counsel.
Okay.
So does that overlap then with the second issue on subpoenas?
The subpoenas would be an additional,
Okay, so then when you're talking about full investigatory authority, then that does not,
include subpoena,
okay.
not at this point.
That's something else we'll discuss then, powers of the EAC, correct?
Yes, sir.
And what about, I know that they had requested the ability to have closed session deliberations,
Of the EAC?
the EAC.
EAC? Yes, it's my understanding that's allowed already.
Is it? Okay. Very good.
Anything?
I think so,
Okay, anyone else?
this section.
Pushkar?
Yeah, I'd just like to comment, I'm really happy to see this come back to the commission. I know this is always a work in progress, and this is how we grow better as a community, right? I was very disappointed in the process when it happened. I don't think the city attorney at the time said a word during the whole thing, and it was left to me to basically try the case, right? And I don't think that's fair as a complainant, and it places a really high burden on trying to do the right thing, right? And so I'm happy to see this go forward.
Anybody else, Commissioner? Okay, that takes us to the next issue, which is the issuance of subpoenas or attachments to compel witnesses and discovery. In my research, I kind of was trying to see if we already had that authority. And under Article 5 of Section 19 of the city charter, the city commission already has the ability to compel witnesses and documents. Now, I can probably assume why that hasn't been done. I wouldn't recommend it unless there was an extreme circumstance.
Would not recommend it.
Right, because of the process involved, you would have to go to, at this point, to the municipal court, have them sign off on the subpoena. It's just, it's a tool, but should be used sparingly, when necessary. I think it acts as a deterrent. I think it acts as an enforcement, just being on the books, knowing that people can, be fined or be in a prison and city jail. And so if you have that on the books, I think you're going to see much more compliance. But the city needs to be prepared to enforce it if necessary.
What's required in the decision? If it exists now, what does it require to issue a subpoena? In other words, does it have to be everyone unanimously agreeing or?
No, from my reading of it, it's just a majority of the city commission. And in this sense, it's limited to investigations related to financial transactions of any city office or department. What we would, and again, this is a legislative body, so you can legislate and create laws as appropriate, not just to financial transactions of any city or office or department. That's covered by the charter. But as you legislating it through via ordinance under Chapter 38, you could have a similar enforcement mechanism. This is just to share that it's possible. You're already doing it. You already have that authority. But you could apply that tool to Chapter 38 if everybody wanted to. Well, not everybody, but the majority of our city commission wanted to do so.
So then the subpoena power that exists now, council, you're stating that the commission itself has that authority, but it needs to be a majority of the city commission that actually authorizes issuance?
Right, correct.
Okay. And that has nothing to do with the
No,
EAC, really?
No.
Okay.
and so that's why I'm bringing it before or to kind of discuss, is this something you would like to do or at least explore? Because if so, I've already reviewed some language for this, but.
Personally, I believe very strongly in the ethics committee and the fact that we have made it so strong that they have the power to remove one of us from sitting here. But I do not think that the subpoena power is of any value. I think if one of us commits a crime, law enforcement has more than enough power to subpoena any record that they might need. I'm not a prosecutor, wouldn't even, that's not my job in here to be a city commissioner, not to go find somebody's phone record. So like if a crime is committed, I will report it. That makes me uncomfortable.
Yeah, Commissioner, as I understand it, your concern is law enforcement already has that authority. I will clarify that although the it says you can remove a city official, it's my interpretation because the way it's defined in our ordinance, it lists city commissioners along with city attorney, the municipal court judge. Those, I do believe you could remove those. But any elected official, the only way to remove an elected official is by recall vote, because you've been duly elected by your constituents.
Okay, so I misspoke, so that they can remove any official.
No, but it's a very good point that you raise. It's actually something that I think needs to be clarified in Chapter 38, because people could argue EAC has authority to remove.
But the EAC just provides a recommendation to the commission.
Right, correct.
They don't have the power to remove any.
Yeah, and even their recommendation, if the recommendation was to remove any member from this, you couldn't remove another member from the Board of Commissioners. So I think that clarification would be useful.
That's the way I understand.
Very good point.
That it's a recommendation from the EAC. My concern with subpoenas particularly is abuse and political agendas. And I'm not necessarily concerned about the committee itself, but I'm always kind of looking at future committees and future commissions and the makeup of these types of boards or councils going forward. And I don't like to leave any sort of avenue for something like a subpoena to be abused or to be used as a political tool. I think that has to be something that's very difficult to get and something that requires, probably a unanimous thing or some sort of safeguard to prevent abuse.
I don't favor certificates either, because I think it's, in my simple thinking, if something is that egregious, it should be referred to law enforcement anyhow.
I just,
To your point.
Yeah, I agree as well. And we've seen in the past, not that long ago, where a subpoena authority there was an attempt to abuse subpoena authority against another commission member by a commission member. And that was something that really was political, and we saw the possibility of abuse on that.
Who until then said that they were against the subpoenas? Was it you, Pedro?
Yes.
Okay.
So if I may, Counselor. First, let me ask, because this is with regard to the commission, this is related to financial transactions of any city office or department. So let's say, for example, in the case of Commissioner Munguia, and this was an outside company, outside consultant, would that subpoena power apply? Because it's not a city department, it's not a city.
Not in this case.
So it,
Not-
powerless in that case, just like the EAC was in this case.
Yes.
Okay, so that's one of my first concerns. Two, if we expect this board to be able to do their job, they need the authority to do that. There's a difference between criminal and ethical. This is not a criminal body, criminal investigation body. This is about ethics. Are there violations of the code of ethics?
Right.
It may not be a crime, but they cannot make a good determination if there was an ethical violation if we don't give them the tools to do that. So I think they absolutely need this power. And then we as a commission need to ensure that we're taking the proper steps to safeguard against any abuses. There should never be a commissioner on the Ethics Advisory Commission, as far as I'm concerned, because the political, and if we see somebody abusing that power, the commission has an obligation to step up and remove that person and shut it down right away. But I think if we want this body to be able to do a job, we've got to give them the tools. And in their expert opinion, they've come to us asking for this now because they saw what not having those tools at their disposal did to that last case. And that was investigating an elected official. So I think we should take that seriously.
I agree. I think subpoena is critical for the body to do its job. In Joel Munguia's case, if the ethics committee had been able to subpoena, they would have found out, was the money deposited in an account that Joel Munguia had access to? And that, I just don't understand how they reached the decision that they did. Because as lawyers, and I think even the guy who's in finance, he would have known, oh, well, just because he's saying that he didn't use that money, they had an agreement with his partner that he wasn't going to access that money, doesn't mean that he didn't have access to the money.
Right. Right now, yeah, I understand there's a clear need for the EAC to have some kind of tool. But I also am hearing others saying that there is an abuse, possibility for abuse in the process. It's maybe finding that balance or that check on it.
I think there should be a real high standard getting to that subpoena. I'm not saying that there shouldn't be. I just think that to prevent abuse, you have to have a really high standard.
And I've heard from most of just trying to give everybody due time, Commissioner Cowan and Commissioner Cardenas, Commissioner Techo, have you chimed in on this one? I think, yes, you did.
I'm the one that said that.
About the criminal, yeah, right.
It's a very, and just my opinion is that if it wasn't such a serious thing, law enforcement wouldn't use each single judge to get something like that done. It's.
Right. Commissioner Cowan?
I agree that the ethics committee needs to have this tool at their disposal in order to fully vet a complaint. But I do agree with Mayor Mendez, there needs to be a high standard, I would say maybe supermajority to cross that hurdle.
How do you get around that, though, if the city commission is not comprised mainly of lawyers or the ethics committee? That's my one concern. I mean, this is such a legal process that we need to have a very well-established procedure. And so when you have not enough lawyers, I think that's when things go amok.
It's debatable, some of that. And no disrespect.
I think that was a lawyer gig.
And honest.
Definitely.
Yes, what I was gonna say is I would like to see some examples, because I'm not a lawyer. But I do fear the abuse of this. I'd like to know some examples, maybe you can provide them for us, of how it has been abused in other communities under other situations, because I don't want to think just about one particular instance. I'd rather look more broadly about the future and what we are looking at.
I do want to give Commissioner,
I just don't want to overcompensate. I don't want to overfix something that may not be broken. Maybe what we're doing is not following the rules and we just have to. There may be some things that could be done when things have happened. They're not. Maybe we're just measuring things with a different stick and that's not right. So we should just be clear on what we want and follow the rules.
okay, so what I'm kind of gathering, did you have something else, Commissioner?
But I don't want for people to get away with unethical behavior simply by pleading ignorance. And that's my one, oh, well, I didn't know. How can you not know? Like, I mean, maybe there is some sort of training that we need as city commissioners before, at the beginning or before we get elected. But
So what I'm kind of hearing from everyone is there do need to be tools for EAC to compel witness testimony and documents. But there need to also be checks and balances on it. Probably supermajority, but also to Commissioner Galansky's point, maybe some criteria on steps before we get there, right? So expectations that, hey, you have so many days, kind of like hate to really get into like rules of discovery, but you have so many days to submit documents. If you don't, you have, notice and I'm sure I can compile some examples from across the state. We're not going to be the first city that's done this before.
I'm sorry to interrupt, but how do other cities handle this? I mean, there has to be a book somewhere that somebody has followed before. Why are we in uncharted territory?
Well, we're not. It's other cities have done it. City of San Antonio, I believe, City of Corpus Christi. I've checked into those, but I don't think any have, and City of Denton. I don't think any of them have gone into detail as providing, maybe as Commissioner Galansky is recommending, maybe certain criteria, so that there's expectations set beforehand that you need to comply with these discovery requests. If it's not complied within a certain time period, you're at risk of being, by having a subpoena filed against you, and kind of like it's already in current, trial procedures.
Yeah, it sounds like, there's a two-step process here. One is just whether it has merit or not. If it doesn't, it gets kicked out. If it does, then it moves forward. Once it moves forward, then it sounds like a supermajority on something like that would work. At least from what we're hearing, it sounds like.
Well, why don't I bring some examples? Maybe this is one of those where I bring some examples, good and bad. I'll bring good and bad, and then we can kind of pick the discussion up from there again.
Okay.
Counselor, one of the things I'd like you to look at when you're doing that also is with regard to Commissioner Galansky's comments. Look at those other cities and instances you're looking at. Do they have provisions in their ordinances where certain qualifications are established for those who are eligible to serve on the Ethics Advisory Commission? I know on other boards, we ask for specific backgrounds in certain areas. That may be something to consider here.
Yeah, I think it's very important. That's a great idea.
I've seen some that require, pastors, priests, attorneys, like a mixture of, different perspectives.
I agree. It shouldn't be all one.
I appointed a pastor because I knew he would make the right choice. And he has a good attendance
Yeah, he
record.
does.
So I'm very
Sure.
I have a final comment. I think, during my complaint, there was a ruling, and then there was supposed to be another meeting to finalize their report. And the ethics committee could not meet quorum issues. During the hearing, there were only 4 people that attended that hearing. And it required a quorum of the group that was there, right? And so they had to have those exact 4 people meet to even discuss this issue. And they had a hard time doing that. It took a month. And I think that's something in the rules that, if you're not present for the hearing, then you can't talk about it later. I know that's
And this is something Commissioner Dos Santos and I have talked about, attendance, and he has some really good points on that. I think hit up on the minute order issue.
They all have a copy of the attendance report, so
Well,
we'll
yeah.
talk about that later
So
tonight.
there's a certain amount of absences, they should be automatically removed.
Removed, correct,
If that doesn't exist, it should.
yes.
Can someone on this, obviously, when they say, I'm afraid, or I don't want to go into that hearing because I'm just uncomfortable with it, are they allowed to do that?
To abstain, I think they just don't show up. That's what's.
Don't show up.
Because I don't think there's a lot of stuff that happens here I'm not comfortable with, but I show up and,
Right.
and I don't think, well, then they.
I think it comes down to the appointment powers of this commission, to regulate that. And what I'll do is, let me go back to the first issue, just to make sure I have a good understanding. We just want, Commissioner De Los Santos, you had the point of having a supermajority. I think there's a general consensus of proceeding with this. Just having a supermajority, define conflicts as to the outside counsel, certain criteria. Maybe possibly even the mayor said an assertion by the complainant. Kind of when we, as attorneys ask for recusal of judges for certain reasons, a certain similar process.
No, this is going to apply also to advisory boards, right? Or other boards?
All boards.
That needs to be made crystal clear to all the other boards that they need to disclose conflicts, because I've mentioned to you before,
Right.
it's not common practice.
The chapter 38, yes.
Mhm.
And I think those are the big kind of recommendations going forward with the first one. Did I miss anything?
Question for the lawyers here. Could the district attorney not subpoena somebody?
Yeah,
It-
the criminal aspect.
And I think that's Commissioner,
Ethical versus
No
ethical violation.
Well, depends on the,
and I think that's Commissioner Tetro's first initial comment was, if this is a criminal
Okay.
matter, you're gonna have the DA's office looking into a criminal complaint, and they'll rightfully subpoena.
When you're involved with monies, it's gonna,
most likely, yeah.
Right.
gonna be, yeah, all right.
Okay, the last set of proposed amendments are chapter 38 of our ethics ordinance. Currently as written, I think there needs to be some clarification that it does apply to 4A and 4B corporations. And that can be either through the applicability provision, which is chapter 38, section 2. Let me get that out just so I can read it correctly.
Counselor, I always thought that 4A and 4B had to do a financial statement. I guess they don't.
No.
Is that correct? If they don't, I think they should.
Right, and that's where I think, because chapter 38, and if you'll allow me, chapter 38, the applicability applies to all city officials. And the definition for city official includes city commissioners, we've all kind of seen the list of internal people, but it also says members of all boards, commissions, committees, or other bodies created by the city commission pursuant to city ordinance or federal state law. And so I think I would argue that 4A, 4B should apply currently. But I know the way this is drafted, it presents an argument to the counter, as in it's not, because it's its own separate entity. It's, there are appointments, but it's run separately.
We could add that to it, right?
And that's the reason for
That would be,
the recommendation.
Well, this financial disclosure caused some issues in the past, Council, before you were here. And at one point, all boards were required to fill out a financial disclosure. That caused some issues amongst people willing to serve. And I believe the commission reconsidered that and changed that. But I think there should be a heightened requirement for those like 4A, 4B for sure, possibly PV, that would require financial disclosure. Most of the others are advisory. There's really no transactional issues with,
I see your point.
but I think some of
we
these,
deal with money.
4A, 4B for sure, PV probably because their budget's bigger than the cities, but
Quasi judicial,
Also planning and zoning.
yeah. That's true, planning and zoning.
I've seen some weird stuff there.
Okay.
Well, that's a slippery slope, I mean, but.
Yeah.
But definitely, I think 4A4B.
I can work on that.
I also think that there's, I guess it's related to this, but not exactly this, I think there's a bit of a difference in terms of you are appointed to a board as an elected official, and you're no longer that elected official. You weren't appointed as a public citizen, then there's a bit of a disagreement as to if you release your seat or not. And I think the two should agree, the city and 4B or 4A should agree on that point. Otherwise, you can flip it depending on the way.
And I agree with you, Commissioner. What I think we should be doing whenever we're appointing, if we're appointing one of ourselves to a board, it needs to be in the motion in their capacity as. That way it's tied to their office. And when they leave that office, the appointment's gone.
That works.
I agree, but it has to agree, so, because
Right.
I understand there may be a little window of disagreement, a fudge room between what 4B says and what we say. And I don't think there should be.
I don't think commission members should serve on any commission board, but I agree with you, Commissioner. I think that would be the best approach.
I think there's a couple where we're mandated by state statute.
PUB.
Yeah, PUB, and I think even the animal shelter mandates at least one commission member
That might be because it's,
as a state.
yeah, with another
So
agency.
in those situations, I think that's where it's appropriate to use that language.
Yeah, this is probably getting outside of chapter 38, but I can bring something back, maybe let's resolve these and then I'll bring that.
Yeah, let's bring it back. So it's about,
We all have the same sentiment and
Okay.
just don't want to be petty by pulling somebody off and making it personal, but it's not fair that no longer being represented and have lost that seat.
so Counselor, then to bring it back to this, there's two topics on here, expanding 38.2 to include 4A4B. I think that sounds like something that everybody's okay with. Same thing with the second. I don't see an issue personally with that. I don't know if any of the rest of the commission does, but
Application.
I mean, basically,
Having them adopt chapter 38.
and then formally adopt our ethics policy.
Right.
I don't, unless, if somebody has an issue with that, please speak up.
No, I agree.
No, I agree.
I agree.
I think has to be.
I wholeheartedly agree with that.
Commissioner?
I think, or go ahead, John.
I think we need a mandate training as well. I mean, they can say, yeah, we're adopting this policy, but they need to be,
Well, we
needs to
gotta
be,
mandate it to us, right?
yeah.
Well, when I was elected, I was required to do an ethics training online. I don't know what happened this time. You were.
Yeah, but specific to our adopted chapter 38. Yeah.
So going back to the financial disclosure statements, it's one thing to require it of the different board members, but then who's going to check to make sure that there's no conflict whenever like certain issues are being presented, unless it's just self-disclosure. But even then,
Yeah, so I think that kind of goes into the disclosure requirements for the second part. I think by imposing a requirement to disclose, it's not gonna catch everyone. It's not gonna catch your bad actors who intentionally are hiding things. But at least it gives the tool, the mechanism that if we find out that they should have disclosed, that's a clear violation of chapter 38. It's not clear right now, and I think it should be.
No, I think all these disclosures need to be available online.
I agree.
To the public.
And they are public record when they happen. I know
It's like ours.
even though when chapter 38 passed and everybody was required, and I know there was a lot of pushback from citizens who were serving on boards and the commission ultimately relented, I had already filed my financial disclosure. And that's because when I've served on boards in other cities, I filed financial disclosures every year. So I don't mind doing that. And I was told, once you file it, it's public record. Even if the city commission pulls back the requirement, it was filed as public record.
And I'll add, it's not to say that by filing the disclosure that there's gonna be some glaring apparent violation because of a conflict, but it gives legal counsel, it gives the staff a chance to advise, hey, yeah, you want to abstain, you want to distance yourself from this process, so there's not a conflict in the future. It just helps prevent those conflicts from occurring.
And to the credit of council, I've had instances where when I served as chairman of the Board of Adjustment, where council would come to me because a case was coming up that we weren't aware of yet. that a possible conflict existed. They've done a good job there.
The other alternative I have here, it's there, but I do think it's a bit heavy-handed, is prohibiting any applications by city employees or officials to apply for 4A, 4B corporations. I think those concerns can be addressed through the disclosure process. And if at anything, I think, your average, minimum wage or lower entry level employee at the city of Brownsville, through this provision would be kind of penalized for applying for, especially in this case, a privately funded kind of economic grant program. But you could decide to do that. It's just kind of thinking at those long-term impacts. That's one of those for this last kind of recommendation.
Could we perhaps say maybe, like management and directors, or make there some type of umbrella that it doesn't affect other people?
I don't think, personally, I think that the disclosure is great and necessary and appropriate. But, there are 1,200 city employees. I don't know how many department heads there are, but there's a lot of them. And just because they're a department head doesn't mean they have something underhanded. They may have a legitimate project that has merit and they've done their homework, and I don't think they should be excluded.
Yeah, I don't think we need one policy to prohibit everything based on position or based on employment, but what I do think we need, and I think there is a situation where it would apply to everyone, even if it's an entry-level employee, if they're in a department that's designing the grant and they're the ones working on it, the chapter 38 needs to mention that in some way, shape or form.
Well, and it currently it says this, and maybe you're saying to go a step further. On 38, 32A, the last portion of that, it says, or advantage beyond what is lawfully available to every other person. And I think in that case, that employee may have had an advantage.
So it seems like we have these things already in there. We don't know.
Well, and we don't know if they apply to
Pieces of it.
4A, 4B
Right.
projects. That's the clarification.
Well, I don't want to get off topic, but I have had a lot of issue with the way that some of the grants have been distributed for me.
Yeah, and we can probably discuss that in another agenda item, but
But I just feel like there needs to be a precedent that this is not an in-house type of,
to include them is what you're saying.
well,
4A, 4B into the chapter 38 application.
just.
Keep them accountable. Yes. Commissioner?
I'm sorry, go ahead.
No, because I'm going to take it in a different direction.
Returning that.
I think of this in terms of the following analogy. Okay, I'm a physician, and if I diagnose somebody with cancer, the last thing I'm going to do is say, okay, we're going to give you whole body radiation. That would be malpractice and a disservice to my patient. I'm going to find out specifically where your cancer is and detail and orient your treatment specifically for that with the least amount of harm to the rest of the body. And that's, I think, what we need here. We don't need a sawed-off shotgun to slash and burn everything, but rather identify where the defect or the gap is and tighten it or correct it, but not leave, Sherman's march to the, that we burned every city in the along the way. We need to use finesse and tact and specific correction.
And I think that the disclosure would facilitate that. Commissioner?
So here it just says like for residential and commercial economic incentives. Maybe, does that include, say, for example, historical tax exemptions? Or now that, I saw Rick earlier, and now they're going to give incentives for if you fix up your property and bring it up to code and stuff. So does this contemplate employees who might own a historical property? Could they be eligible to apply for that?
This specifically addresses economic incentives, and because it's tailored to 4A4B, I don't think it would touch on like the beautification or historic preservation type of programs. I mean, we could draft it that way, or we just leave it as is.
I think we should contemplate it too, no? Because
I don't under, I mean, I'll be honest, you know, I had and no longer own a historic home that qualified on state and national level. Why should I be prohibited from taking the tax credit that, you know, somebody else down the street, a teacher had?
Especially if it's something that's available to everybody else
It's available to everyone.
and or been approved by a state or federal agency.
And I think the key in that part is, I believe, I'm always feeling that you exclude yourself from the participation of those
I did
decisions.
not vote on it, that's true.
And so, but that, again, that's the key to having that disclosure requirement, is that we can then help silo that and protect or preserve the, I guess, the validity of that decision.
I wasn't even thinking of y'all. I was thinking of really like a regular city employee if they live downtown or something. Are they eligible? Like, do their directors encourage them to apply?
I sure
for that?
hope so.
Currently, they are.
Right now,
Currently, they are.
they're eligible.
Right.
Issue, like you said, that was.
And this change specifically to economic incentives for 404B corporations, it would not impact those employees from applying.
I think it'd be important for us to add on there, if you work on a grant, like, you can't apply for it. You just can't do it. If you set the guidelines, you shouldn't be near it.
It's a grant or project? I mean, is it always gonna be a grant?
I think that has to be done by legal. I don't know the technical terms to it, but I think it's important for that to be very clear. But I don't think we should hit somebody who works in Parks and Rec, and they're gonna go put up a restaurant downtown and take advantage of the grant, that they can't do it. I don't agree with that. I think they should be able to do that.
So disclosures, I'm getting a general consensus for disclosure. That's, everybody agrees with disclosure. As far as it goes to prohibiting employee or elected officials, I think it's mostly been mentioned, like employees in the drafting of these programs and projects, they can't individually apply for those projects or programs or incentives. Let me come back and maybe do another presentation on that, because I really have to kind of think about unintended consequences and how to gather everybody's comments into one ordinance and where it should go.
I think Pedro brought up a good point because, for example, you said an example of an employee in Parks and Rec wanting to open up a restaurant. That's different if it was someone like from planning
I agree.
or health, public health, right? That knows the process of how to do it and can expedite things.
Now, question, would it be, are you extending this to, if you go to prohibit the applications, do you extend that to family members, and how close are the family members? Or we do spouse, or we do kids? What if my son's 35? And I'm thinking, I mean, in the future, we have a city commission who's gonna have a 35-year-old son, and they wanna go out there and get one of these, whatever it may be at the time.
If
We can do that.
if we applied it currently and making it, because we're now making 4A4B comply with Chapter 38. Chapter 38 already requires that there be, you know, I forget the term,
It's like,
private interest into projects. It already applies to family members right now, right? That you directly, for things that you have direct authority over. So to answer your question, this would prohibit that from happening, from having somebody's child.
5-year-old.
lives in another home, pays his own taxes,
Right.
not apply for this?
If you adopt a prohibition against application of 4A4B programs, they would be prohibited from doing that.
But I think from the comments I've heard up here, I haven't heard anyone advocating that we do this yet. I know we're talking about this a lot, but is anyone saying this needs to happen, the prohibition?
No. The disclosure, yes, yeah. But I heard like a subset of maybe direct creation of a program or a project, and those specific limited cases, those individuals would not be able to
Yes.
comply. But that's separate and aside from this. So that's why I'm saying that, bring that back. Right. But I don't think I'm correct.
But would it apply to every single member of that department?
No, just my understanding, just the one has direct contact in drafting all that stuff.
Which most of these, like 4A, 4B, most likely, everybody that works there is gonna touch it. I mean,
So-
or
No,
involved.
no, I think at the very least, my opinion, as elected officials, we should not be allowed to participate in any incentives that the city or city entities offer. We're all insiders. We all know what's going on. We all have direct influence over staff. I don't think it's appropriate. I don't think it looks right to the public. We shouldn't have, we have no business doing that, in my opinion.
I agree with you. Or an extended family, yes. Because, yes, what if, sorry, I was talking. I agree with you. Because, sorry to use you as an example, but when people didn't know that it was you when you got the $80,000 grant. And so once that came out, like, they're not really gonna have.
And I just to kind of, again, keep it focused on this, I don't think anybody's disagreeing. The disclosure part is an improvement that can be added to chapter 38. And I think that's kind of what we're saying here.
Just because he disclosed, like I mentioned earlier, the board though doesn't have the gumption to go against like, oh, well.
Well, in a
Well, and
case like that, then I would say that that goes to the specific requirements of the funding. And that is something where the entity itself should state who the members are.
Well, and right now, there's no accountability for 4A, 4B corporations in complying with our chapter 38 requirements. And so I think by adopting the first three, applicability to on 38.2, and then having them adopt chapter 38, and then also having the disclosure to both the city and 4B corporations, I definitely think that's a positive and progressive step forward to making sure that expectations are clear.
It needs to be fair to the public, because it's not fair that we're doling out millions of dollars. And I give Roy for his house, and I give Nurse for her house, and I give Trey for, it doesn't work like that. It's for the whole community.
Right.
My anger, and that's I go to sleep angry every night knowing that this is the way these boards are working. It needs to be fixed and it needs to be fair.
And to your point, we should probably limit how many times someone can get a grant.
Absolutely.
So
And it won't, yeah.
when I was chair, did have a requirement that you could only have one active grant at a time. That was undone by the
Yeah.
boards that came after.
I called Josh and asked him exactly that, and he said that is no longer on
But
there.
it was something that I instituted that was taken away. Now, at that time, there weren't individuals applying for grants, it was entities, but
Perhaps.
And yeah,
I think that more clarity and consideration needs to be given to adult children. And you can say, well, that's just because you have an adult child. Oh, children, okay, that's true. I'm the oldest one on this board. Your kids are not old enough to be adults and others don't have children. But I'm speaking for the children of people on other boards and city employees. If your adult child is independent and has been for years and doesn't live with you and isn't on your tax return, I don't believe they should be handicapped just because I chose to run for elected office or Howell chose to be the director of the multimodal department. Unless I was involved in creating the opportunity, or Howell was in that example. I'm sorry, I just saw you when I. But that's what I'm saying is that I don't. Again, that's slash and burn as opposed to selective consideration in individual circumstances.
I think I have a good direction from the commission, but I'll leave it up to everybody else who wants to say one last thing.
I think in the last application round, I saw the list of applicants, and a lot of them were just entity names, right? And I think we really need to define what the requirements are to disclose. They need to put all the owners of all the entities so that it's not just the majority owner, the
Yeah,
manager.
1%.
Everyone that's involved in that entity, so that everyone knows who's involved.
That should be part of the
There's no-
application.
I agree.
Well, when I applied for PPP, it's real simple. They didn't make it up. You go on there, when you put your name on there, it asks you for every member of that LLC. And it's just simple. It's very easy and it's very clear.
Mayor or?
I agree. I think that some of this can be fixed through BCIC itself and in the actual regulations, the way that they, I guess, handle the application itself, there should be a disclosure of all members. There should be a disclosure or a request to state any member or partner or any individual with an interest. And there should probably be a separate box for whether that individual's a commission member or city employee. That way, at least it kind of tags it for the board to know that as well.
And I think that can be tied in definitely into the, that last recommendation we're doing about the disclosure. Commissioner Galansky.
So what if I want to change some of the BCIC rules? Like I can't really go in there and reach, but I think so, and I'm almost not confident that the board will read my mind and make the changes that I think are prudent.
That might have to come from you, council.
Yes. Well, and it's when I bring back the amendment, I'll bring it back with a way, because this is the enabling body that created those two corporations. So when I come back, I'll identify the process and making them comply with Chapter 38. Commissioner De Los Santos.
I do.
I'm sorry, Commissioner Glassie, if you had something.
I do, not specific to what you've covered so far, and this is a good start, but I've got several other points that are specific to Chapter 38 that I think need to be addressed. So if you guys will indulge me for a second, and some of these might be repetitive.
Or if
Does that have anything to do with
Because-
discussing?
because we can actually, because I'm going to come back and bring other items. If you want to come over to my office and we can put them on the next time, because I'm bringing back the one about the prohibited any actions on FOIA for B corporations. This is open up to all Chapter 38. So if you just want to give me a quick rundown.
That's my intention.
Okay.
Yeah, but if it's, Roy, if it's better, I want to make sure that you address those. But if it's not one of those four that we discussed today, I don't want it to end up.
Then my question is, how come it's limited to these four? Who got input on what was going to be presented today that we could talk
I have no
about?
idea.
I didn't have input on that. And now I'm going to be limited on what I can and can't say with regard to 38? That wouldn't be appropriate.
The way it was posted was Chapter 38 and proposed amendments.
By whom?
By me, and I drafted it that way because if there were, I wanted to allow some flexibility. So that's what I'm saying. I'll allow, just give me the list. I just can't provide any responses to those right now.
And that's fine.
And
But I want it on the record.
Commissioner De Los Santos' recommendations, they're all fair and they're well reasoned.
So go ahead, sir.
First, the time period which a prior relationship must be considered a conflict and recusal mandatory. And this was something that came to light, I think, in Commissioner Munguia's case, whether or not he had divested himself 30 days before or hadn't. But I think 30 days is still not even a long enough period of time. I think we need to look at either 6 months or a year for any type of relationship, either before you vote on that or even after. Because if I give somebody $1 million grant today and tomorrow they give me a cushy job, that's a violation as far as I'm concerned.
Okay, can you, what section it's?
No, I,
Okay.
I did, I'm emailing you.
Well, okay, and then we'll follow up with our own personal.
Certainly. Financial disclosure, and I know we've covered this, but yeah, required financial disclosure for all board members and any bodies which are not merely advisory, or more importantly, which handle large sums of money, board contracts, incentives, and or which apply the law to citizens' rights, and additionally, the city auditor. I see we've got city attorney, city manager. I think the city auditor should be one as well.
And then we're adding also 4A, 4B, PUB, those, right? I mean, because we had talked about that a little earlier.
Yes.
Okay.
What?
Sorry, I'm reading.
Well, oh no, that's okay.
Roy, can I interrupt you?
That we can take offline.
Can you repeat what you said about the auditor? Because we didn't hear you.
Oh, I think the city auditor is someone who needs to provide a financial disclosure as well.
Okay, got it. I agree.
I think the Ethics Advisory Commission, and this was identified in a current case, needs the option to summarily dismiss a case if they see that it doesn't have merit. This is a case that got past the preliminary panel. The preliminary panel said, absolutely, this is a case that should move forward.
And Commissioner, I'm just, because it's ongoing, we can talk.
That works.
But I do note your comment.
Like a summary judgment.
Right.
Right.
That needs to be visited. And then I want us to look at the preliminary panel because that's something could get past them. That's a concern. And also that we should outline the process of members of the Ethics Advisory Commission, should it be warranted.
I think you need to specifically look at an attendance requirement. And I'm surprised it's not on there, actually.
Yep.
Wouldn't they be subject to the?
And
email them to you.
Yeah. All right, commissioners,
Oh, wait, can I just go, so one of the rules here from the ethics committee is that you have only 1 year. 1 year has to pass before you can do business with the city. I was thinking it might be more appropriate to increase it to 2. I don't know, to 2 years?
years after.
It's pretty common in most public entities. Like I know at TSC it was 1 year. I think that's pretty, but look, see what other places do.
I can bring some examples, but also added a list of,
Mhm.
After you're out, and then there was another one that was on section 38-230, which 230. Oh, for disqualifying from a contracting. I think it's at 2 years, that once you're disqualified from contracting, you're only punished for like 2 years. I think we should increase it to 5. But if anyone would be amenable to that.
I mean, what does everybody else do? Why are we putting?
well, it's really specific to the communities, right? I mean, bigger cities don't have time to kind of, like, I mean, your metroplex areas like your Dallas, Fort Worth. But like your other communities, mid-sized communities, they're along these lines. It depends on the community and the development going around and the specific issues they're dealing with. Commissioner?
So, I didn't, again, maybe it's because I'm on the end, but I didn't I heard 5 years, but I didn't hear
So for example, and this is based on my experience with PUB, if you have a vendor who then like did something not kosher and they get punished, we're not gonna do business with you. Right now, the rules say that they can only do, they're punished for 2 years.
Oh, I see. And you're
Something-
suggesting 5. Okay.
Yeah, it's 38, 230.
230.
I will definitely bring those back. And probably after we get a good draft of these, and maybe just as a follow-up on meetings, as the progress of these other items as well. If nobody has anything else, I think I have some good direction, and I appreciate everybody's comments. Thank you.
Thank you.
Thank you, Counselor.
I mean,
I'd like to ask Commission, I did get a request from our county judge who's going to present an item that's on the agenda, whether we consider taking that item out of order because they're on a time crunch. But like, nobody has an issue with that. I'd like to take that out of order. That's.
Take it out of order.
Second.
For a motion and a second, those in favor?
Aye.
All right, let's take it up. I'm trying to figure out which one it is. I believe it's individual consideration 1.
Yes.
Judge Trevino, are you here?
I'm here. Can you hear me, Mayor?
Yep.
All right. Good afternoon. I'm sorry, was somebody, did I need to
Yeah.
clear something?
She just needs to call the item.
Go ahead.
Judge.
Go ahead.
Items for individual consideration. This is item 1, consideration and action to approve resolution number 2021-075 to support efforts to improve the quality of life within our community to enhance local opportunities, host large concerts, major attractions, and community events such as graduation ceremonies, as well as enhance the economic stimulus that will benefit all businesses within our region and county that provide for hospitality and entertainment services. City Manager's Office.
Floor is yours, Judge.
Thank you, Mayor. City Commissioners, good afternoon. Thank you for having us. I got an email from the mayor asking to keep it short and sweet. You guys know that's going to be hard for me to do, but I will certainly try to comply. Anthony, there we go. We've got a short presentation, and Anthony Lopez with my office is helping me with regards to the slideshow. The purpose of the presentation and the resolution that is before you and the City Commission this afternoon is for the Cameron County Visitor Venue Project. We have commissioned a feasibility study which has indicated the viability of this particular project, and as some of you well know, the purpose of this particular arena is a multi-purpose intention for entertainments, concerts, sports arena, community events. Greg both go to visit in San Antonio, Houston, Dallas, or elsewhere. Look at your hotel bill. There'll always be an extra tax there, usually a visitor venue tax that the local community or local government utilizes for the benefit of its residents, usually a quality of life. That's exactly what we're talking about right here. This particular proposition is on the ballot for the November 2nd constitutional general election, which is normally not that well, does not have a great participation, but that's why we want to make sure that everybody's aware of this particular proposition. Some of the benefits with regards to, I'm on page 3, Anthony. Some of the benefits with regards to the venue project, most importantly, is that there will be no cost to the local taxpayers. It will be funded and paid for by the visitor tax, which is a hotel motel occupancy and car rental tax here within the county. Obviously, new jobs will be created both during the construction phase and during the operation once it's completed. More than anything, it's going to create a destination site for us here in northern Brownsville and Cameron County. Increase visitors and tourism to our county, have a positive impact with regards to the county, and obviously enhance the quality of life in the county. What's the visitor venue tax? I've mentioned it's a hotel motel occupancy tax added to the bill on a hotel stay or rental car. Most importantly, who pays this venue tax? The visitors, not you and I, but those visitors that are staying at our hotel and motel or visiting. Will this increase our property taxes? Absolutely not. This is not a property tax and will not be added to your property tax bill. The general fund nor the property tax rate will be associated with this particular project. Where is the arena to be located? You all will recall that several months ago, in collaboration with the city, we approved the TERS number 4, which is basically on the north end, north of Rancho Viejo, and it's going to be off the intersection of Highway I-69 and 77 and Highway 100. Basically 5 minutes from the center of Brownsville and 10 minutes from Harlingen and 25 minutes from Hidalgo. The ballot is fairly lengthy. It requires all of this particular language because the state attorney general insisted, and in order to be in compliance with the statute, needs to include all this. So it is a long, but basically it indicates the venue tax is already being taxed. I want to make that clear. This is not a new tax that will be added to the visitor tax. It's already being included. The venue tax is already included with regards to that. We've done this before at the county level. If you all have visited our amphitheater and event center at South Padre Island at Isla Blanca, we opened it approximately 2 years ago. Obviously, COVID, the pandemic had an impact with regards to our ability to continue to operate. But as we get back up off of the floor, we are having more and more events. We are also getting ready to open up the South Texas Ecotourism Center in Laguna Vista, hopefully by the end of the year. These two projects were approved by the voters previously, I believe in 2016, and that's why we want to add the arena project to the approved list to utilize the Cameron County Visitor Venue tax to support this. Hopefully, I was as short, as brief as you wanted, Mayor and Commissioners, but I'd be happy to answer any questions that anybody might have.
Hi, Judge. Can you hear me okay?
Yes.
Okay, so I have 2 questions. One, I'd love to see, not necessarily now, but at some point, exactly where it's going to be positioned and how it's going to be oriented. But the other is that I hope that you will design it such that the people living in Madera someday will be able to walk or ride their bicycle to this venue.
That's a great point, Commissioner. And that is part of the reason why we're working with the developer. The TERS has committed basically a third of the proposed construction cost, which is approximately 100 million. And this is just a rendering that we've got right now. It's not set in stone. We hope to get some public input, obviously, from each of you and the public at large. But this is just something that we wanted to be able to demonstrate. But yes, it's being done as part of the master plan development of the Madera project. Honestly, when this is all said and done and we get this approved and they begin their project, I think it's going to be one of the most, if not the most beautiful locations in the entire valley in which to live and work.
I just don't want to see it, and it sounds like you're looking at that. I don't want it to be like a Brownsville Country Club kind of neighborhood that you can't get to the mall unless you drive there.
No. That is one of the keys why we wanted to pick this spot, because we want to make sure that when people go to the events, that they're able to get in and get out right away, and that it's taken the future development, which includes multifamily, which includes residential, which includes commercial and retail, all part and parcel of the project. So the initial layout, if you will, and design for the project is taking all of those issues into consideration.
And Judge, what's the proposed timeline for this project?
Well, first things first, right? We gotta get this approved.
Right.
But hopefully, and the developers getting ready, they're already moving ground as we speak. I don't want to be wrong, Mayor, but probably anywhere on the short end from 2 to 3 years to probably to 4 to 5. But the sooner we get started, the sooner we finish.
Thank you.
Commissioner Cowan? Yeah.
I have a question on the ongoing maintenance and operations. How's that going to be funded?
Well, the game plan there, Commissioner, is we are speaking to third-party operators who are in the business. That's our kind of our goal right now, and we're also talking to some different professional sports teams with regards to that particular aspect. Our focus is on building it, and then we want to basically make sure that the operation and maintenance is not necessarily a responsibility of the venue tax going forward. But we've got state and federal grants that we are looking at and getting ready to make applications for to make up any shortfall with regards to the construction. And by finding more and more of those dollars, we think that that's going to be able to impact the ability to, with regards to the operation itself of the arena. Anyone else?
I just have a
I want-
comment. Rick.
I
Hi,
was
Judge.
going to say, I want to thank Commissioner Techo for joining us for lunch last week. I had lunch with the mayor, and she came as Mayor Pro Tem, and it was to basically do the same type of presentation. So I want to appreciate her for joining us last week.
Thanks, Judge. I just want to say that I'm so proud of you and your team. This is so exciting. This is long overdue. Our community has deserved an arena of this magnitude for so long. I think it's so sad that we have to travel more than 60 miles to see a basketball game or a show or anything like that. And this brings the possibility of a team or something exciting coming and making this their home. We have a rocket, we're gonna have our arena, and we can only imagine the type of retail and lodging accommodations that are gonna follow with this. So this is so exciting, long overdue, and the best part about it is it's relative closeness to Brownsville. If it's not in Brownsville, it pretty much is. So
The city of Brownsville is obviously going to benefit tremendously, but most importantly, we wanted to take a regional aspect with regards to this, and the entire county will benefit from this. The island, obviously, it's going to be right down the street from Highway 100, so that's obviously a plus. But we have to think big, we have to think regionally, and most importantly, we have to think collaboratively. And I want to thank the city of Brownsville for helping us get the TERS established so that we can move forward to present this before the voters on November the 2nd. Oh, by the way, early voting starts on October the 18th. Obviously, this being a constitutional election, it usually does not garner a lot of attention or voters, but we want to make sure that we get as many people out to support this project if they're in favor of it.
And the last thing I have to say is I'm very impressed with the creative funding. You know, usually when these projects happen, it has to come out of, you know, taxpayers' pockets. But this money is already in a fund, right? And it was mostly funded by South
Exactly.
Carolina visitors.
Exactly. It's already being paid for by the visitors to our region, to our county. So you and I will not be paying for this, not with our property taxes. So that's why we're looking for these different ways to fund what we've already got planned, and obviously any potential shortfall that we have. That's why we're looking at the state and federal grants. And right now, there are quite a few available that we're looking at. And that doesn't even get into some of the other ways to help fund the arena, which we can discuss down the road.
What else?
I'll wait for discussion.
Thank you, Judge.
Thank you for having us. I appreciate it very much.
Yes, sir. All right, do we have any motions on this item?
A motion to approve.
Motion to approve in a second, discussion?
Just one comment I'd like to make for the benefits of folks watching at home, the taxpayers. The call outs were, this does not affect our local taxpayer. This will not increase your property taxes. But I think an important call out also is this is the type of advancement and development that we need to be doing more of. commercial enterprise like this, more industry is what will get us to the point where we can reduce our dependence on property taxes and better balance it out so that our tax rates are more competitive with other cities in the valley. So this is something that's absolutely a plus for Cameron County and Brownsville.
Thanks for seeing that.
And I agree, and I think what you said, Judge, was very well stated, which is we need to work collaboratively, we need to work together, we need to think big. And that's definitely been our approach, and I appreciate you saying that. So unless anybody else has anything else, those in favor?
Aye.
Aye. Those opposed? Motion passes. Thank you.
Thank you, Mayor. Thank you, City Commissioners. Appreciate your time. Have a good meeting.
We'll move back to presentations. The presentation by Half Associates Incorporated on the final update of the Sidewalk and Trails Master Plan, Multimodal Transportation Department, Mobility.
Yes, good evening, Mayor, City Commissioners. We are in the final stages of our master plan, and so we've asked our consultant virtually to do a 137-page slides presentation. But Jackson is really good. Jackson, are you online? I think he can do it in 5-10 minutes.
Jackson, just out of respect for the commission, just, as concise as you can. I know Commissioner Gowan is paying the closest attention. So if you could look at anybody, look at her when you're presenting, but yes.
Mayor, Commissioners, I'm John Clint with Half Associates. I'm the Operations Manager here in the Brownsville office. And 11 months ago, you all hired us to do a comprehensive bike and trail sidewalk master plan that aims to ensure safe, convenient, and attractive user-friendly options for various implementable strategies for non-vehicular transportation. In the last 11 months, we've had 6 community engagement opportunities. And even with the COVID and the social distancing, we had over 1,000 survey response online, which I thought was pretty impressive when we started this project. Master plan proposes over 200 miles of proposed bike lanes, trails, multi-use paths, and of course, sidewalks. Now, y'all mentioned Jackson Marble's going to be going through that. He was present for most of these activities. He's been down here, and he's actually had some great experience with our local food during the times he's visited the last few months. So Jackson, go ahead.
Thank you, John. If we can go to the next slide. As John said, this is a bicycle and trails master plan. This is an update to the 2013 bicycle and trails master plan. Although this is one of the first comprehensive city documents to include a sidewalks plan. As John stated, the goal of the plan is to ensure safe and healthy transportation options, a network that meets the community's needs and what they want. We will introduce and propose new development, and then also provide you with a list of goals, objectives, strategies, and actions that are implementable on a timeline. As John also said, we have sidewalks, off-street recreational trails, multi-use paths, protected on-street bicycle lanes, and sharrows or shared lanes. There's over 200 miles of proposed network, and this also includes trailheads, which are trail entrances, places where people can park, people can rest and stop. It also includes over 252 potential locations for pedestrian refuges in the medians when crossing the street, and also 37 pedestrian bridges. The goals of the plan: 1, create a well-connected system that provides safe and convenient access for everyone in Brownsville. A network that is designed according to the needs of its users. Provide opportunities during the implementation of the plan to have collaborative efforts between local businesses, citizens, and entities. And then also showcase Brownsville as a premier destination for trails, active transportation, and the natural landscape that you have down there. Each of the goals is split into multiple objectives, strategies, and actions that can then be implemented in a step-by-step process and way. It is very thought through, and it's in an implementable type of process. The plan is split into 5 different chapters that build off of one another. Next slide. Thank you. Throughout the process, we had over 6 different opportunities for communities to engage either in person or online. As you might know, we had the bike ride with the city manager, an open house. We had attendance at 3 farmers markets. And then we also connected with some of your local businesses to provide food or support or feedback on the plan as well. These are some of the pictures from the community engagement opportunities we had. When it comes to the community feedback, a majority of this the major concerns were safety, mobility, lighting, cracked, uneven pavement, and what citizens most wanted to see were bike lanes separated from vehicles, connections to schools, local parks, and downtown, and as well sidewalks along busy arterial streets where they currently do not already exist. This is an example of 2 of the analyses that we did on the plan. The first one to the left is an accidents analysis of pedestrian, vehicle, and cyclist collisions. This helped guide where further analysis was needed and where additional safety recommendations should be made. To the right is a service areas analysis of your existing recreational trails. This shows a 1/4 mile and 1/2 mile distance from each trail. It's in hopes that in the future, all residents, businesses can be within a 1/2 mile distance, which is a 10-minute walk from any trail, no matter where they are in the city. We also looked at all 52 BISD properties. We assessed the safety and the mobility and connection and access to those schools. And we also did a very similar analysis for every single interstate overpass. We looked at each of the trail crossings as well and assessed them based on their signage, the lighting, the landscaping, and clarity of the road markings as well. We also did an inventory of all of the amenities and elements along each of your existing recreational trails. This was to guide what part of the trail needs additional elements, where can a bench or light be placed, and hopefully this is the start of a comprehensive asset management program for the city and the Parks and Recreation Department as well. Throughout the community input and surveys and analysis, we found that the overall condition of sidewalks, along with the maintenance of the infrastructure, was one of the more common conditions found, as well as ADA compliance in the downtown, which is curb ramps at intersections. There were still many, many intersections in the downtown which needed to be ADA compliant or needed curb cuts, or there was a conflict with existing light poles or infrastructure. This is the proposed comprehensive map for trails, on-street bicycle lanes, sharrows, and multi-use paths. We can go to what we just saw was the sidewalks map. So that would be all new construction of sidewalks. And what we are looking at now are the top 13 priority corridors where improvements should be focused. The next few slides are some renderings of specific locations in Brownsville. This is the crossing of the historic Battlefield Trail and Price Road. This is what is a pedestrian refuge, or some people call a pedestrian median. This is to ensure that people have enough time to cross for crossing signalization. It as well helps with the perception of safety because when people are crossing more than 3 lanes of traffic, oftentimes it can feel unsafe or they feel like they have to rush. Next, this is a before and after of different painting that can be done at interstate overpasses to increase visibility. To the left is an example of a trailhead. This is on Dennett Road, which includes parking, landscape enhancements, and shade structure. And to the right is additional landscape elements and placemaking on Palm Boulevard and the Belden Trail. So this includes opportunities for additional lighting, additional signage, additional artistic elements, natural plants, and a different pavement type to delineate the road from the pedestrian crossing. Lastly, this is an example of our implementation chapter. This lists all of these specific initiatives and actions within each of the strategies, which then gets compiled into the objective, and then you can reach the overall goal of the plan. And as well, we provide a comprehensive list of each and every trail's cost and all of these specific elements. Unit aggregate costs for what is in a trailhead, how much for a specific 1 mile length of trail. And then that concludes the presentation. I would thank you for letting me speak. And if you have any questions, I'll be happy to take them.
Go ahead and let Dr. Gowan.
Thank you for your work. I have to say that you guys your company impressed me back for the first time that you did the trail and master plan. And you have not disappointed this time. In the first plan, which was, by the way, paid for with the plastic bag ban fund, so it did not come out of general fund. I always need to remind people of that. It was proposed that everyone in Brownsville, every home in Brownsville be within 1/2 mile of a bike lane or a trail. Is that still true in this current plan?
We believe so, yes.
Okay.
Yes.
Second, is this process over now, or since just got approval to have groundbreaking of the West Rail Trail? Are there any recommendations that can still be inserted with respect to the West Rail Trail?
We can, Commissioner. We did send out the link to the document during a commission check-in to the city commission. We also had the actual hard copies delivered to city manager's office, and so that was communicated. And so we have until this week, so the consultant can go back, any final edits, any final comments that once you ought to be incorporated, we can sort of do that. Once we get everything together and they make the edit, we'll add it to the next city commission for final adoption. Once y'all approve it, then we go back and start working on some of these line item projects.
I mean, understanding we can't change the route of the West Rail Trail, but if there are considerations at crossings or whatever, I would like that. And then finally, I remember in the beginning, I challenged you to make sure that the plan had some really wow factor, not just the easy things to do, but the really platinum stars. Wow, we could never do that kind of items. And
Yes.
I'm sure those are there, and you can send them to me later because I would love to see them.
Yes, there are some very ambitious recommendations in there as well.
Excellent. Thank you.
Yes, correct.
Questions, but I think they're more directed to you. Because I know that I went to this, but this only applies to city property, right? So like over by Lopez, where it's county, can we still do stuff like that over there, or that has to be different?
It would create a partnership with Cameron County, but we can obviously work with them to implement something.
But that goes to the schools, and I think the schools is very important. And I know that there was a mention of schools, so.
So yes, we did actually look at some areas. So all BISD schools were looked at. There is a portion in there that it is city property where the idea is at. Frontier, correct. So yes, it's just working, identifying what needs are there. If they're not there, then, and then working with county.
So I think if you're gonna seek any funding for this, it would be important to get some collaboration, some support from BISD, especially if you're doing it around schools.
Correct. Yes, fair.
And then the other one, whoever's in control of the slides, can you go back one or two? There was one where it looked further back, again, like, and one more, that one. So is that green stuff gonna be raised? Is that the plan, like to do like a protective island for?
It's up to us. These are just recommendations. When we actually implement or construct, we can have more of a raised median that protects the pedestrian there. So it would be up to us. It's a more cost, but we can do that.
Cause I was all in favor of that, especially on Boca Chica in front of Walmart, because I was like afraid of my constituents getting run over. But then like with the flooding on Friday, people were complaining because there was flooding on the edges of the water and they usually drive along the middle. And so how do we resolve that? That's just, like, if we ever come to do that, like if we can contemplate that.
Okay. Yes.
So you could do it with paint as well so that it's even. But in my opinion, my 2 cents for that particular crossing, I hope you're still there, Jackson, is depending on the time of day and the way the sun is, the cars often, at particular times of the day, they can't see the light change red. And so I have a couple of times almost gotten nailed because the sun's in that particular spot. So my question is, the refuge, I love refuges, but is there some other way to position the light, the traffic light, so that the sun at those times of day does not blind the driver?
We can, Commissioner, something we'll work with engineering and public works to think of innovative ways to address that.
I think there also needs to be a drainage component in certain areas, kind of like what was on Ringgold. I know that you, or not you maybe at the time, Foyle, but I know that it was planned to have a drainage component on that sidewalk. So I think in certain areas, I'm not sure if that's been contemplated or not, but that's something to kind of look at.
Okay, that's something, I don't think it's part of this plan, but we can, in the implementation, we can focus on that.
Well, guys, thank you so much.
Thank you.
Thank you.
Our next item is consent agenda items 1 through 9.
Do you have any motions?
Move to approve.
A motion and a second, any discussion? Those in favor? Aye. Those opposed? Motion passes.
Okay, we'll move on to items for individual consideration. And next is item 2, consideration and action to award task order number 9 to Javiation Incorporated in the amount of $1,688,791 for the design and fee for the reconstruction of runway 18-36 at Brownsville, South Padre Island International Airport as budgeted, Airport Department.
Good evening, Mayor and City Commissioners. The airport back in 2020 did a pavement maintenance study, actually to evaluate all the pavements, which basically did the runways, taxiways, and several of the ramps. The data from that study indicated that runway 1836 needed to be reconstructed. We had it in our CIP to be rehabbed, but the data from that study came back and said that that runway needed to be reconstructed. We did receive a CARES Act grant back in 2020. And after several discussions with the FAA, they were able to rescope that grant to cover the design cost for this project. Javiation, which is one of our on-call consultants, submitted a design cost of obviously $1,688,791. And because of the cost, we reached out to Garver to do an independent fee exam, which is required by the FAA. Their independent fee exam came in higher than the original design cost for Javiation. So therefore, what we're trying to approve here is task order number 9. The airport is recommending that you approve task order number 9 for the design of the reconstruction of runway 1836. And again, that is only for design and bidding. We are still working with the FAA in terms of construction, but this will enable us to be able to at least have the plans and specs on the shelf if we can come up with some dollars from infrastructure dollars or some other dollars that may come through. So we're still working with the FAA on the funding portion. That design right there is breaking up the construction real early on into basically three construction phases. It is a total of about a $24 million estimated cost as of today.
Okay, so just to clarify then, the funding for this would come from previously approved monies that you still have, right?
That's correct.
Okay. The project estimated cost we know is 24 million, but is there any sort of time? I know Commissioner Galante had that question, whether there's any sort of timeline on when they may happen. I see it's 3 years, but I guess more specifically, what would come after this? Would you then try and seek this funding, or what would the steps be after this if you approve it?
We're actively talking to the FAA right now about the funding for the project. It is already in our CIP that we submitted to the FAA last year. We submit that program every year, which again will be in December. So we'll do that again in this December. But one of the conversations that we had with them is they weren't able to fund it all at once. Therefore, we were talking about phasing that over 3 years. When we did talk to the FAA, we did ask them if it was, if we should move forward with the design. They said yes. We want to get the plans on the, basically on the shelf. In case we do have some additional infrastructure funding that comes through, obviously, through these bills that are going through DC now. So we want to be in a position to where if there is funding that come available, we can basically pull the trigger and get it awarded and under construction for 3 years. Typically, once they commit to the first phase, they're going to commit to the second and third phase typically.
And a concern I had is I see that the company here is Javiation. I know that they're also the company that is working on the spaceport application.
That's correct.
You mentioned that there's a list of providers that you went off of, but who else is there? Because the last couple of projects I've seen, it's been the same company.
That's correct. We have a request for qualifications process that we have to go through in terms of doing federally funded jobs through the FAA. We did do a request for qualifications. We did choose 2 firms for that under that first request for qualifications, and basically one, so we can pick and choose. So one firm basically would do the design and construction management. The other firm would do the independent fee analysis. Garver is actually doing the construction administration for the terminal and parking lot. So they're doing other work, but basically we have 2 that's on the shelf. So if something like this does come about, we do have the other firm that's non-biased that can do an independent fee exam if required.
So who else though was considered besides Javiation off the list?
Well, the only 2 that we have for construction, which is engineering and construction, is both Garver and Garver.
So those are the only 2 that you have?
That's correct. And we have one other engineering firm that we use completely for planning.
I have some issues with that. I think you need to expand that because otherwise you're just having the same companies all the time. And you only have 2 and you kind of just, something like this, if you design and come up with a cost, I just have some concerns about that, Sean, just being honest. I don't want any appearance that anybody a chance.
Yeah, it's out for 3 years, 5 years, and I think they're in their 3rd year. So as soon as we get to that 5th year, then we'll go ahead and do that process all over again, and we'll do the request for qualifications all over again for our architect and engineering firm.
Are there a lot of firms though doing airport work?
There are a lot of firms that do airport work, and we go through that whole evaluation once we get those submittals. And yeah, it's a formal request for qualifications is what it is. Not based on cost or based on fees or anything. It's just based on qualifications.
I have no problem. I'll move to approve the request.
We have a motion to approve. Is there a second?
Second?
Motion and a second. Any additional discussion? Those in favor?
Aye.
Those opposed? Motion passes.
Thank you so much.
I'm going to abstain on that one.
You're going to sign? Okay. Item 3, reconsideration and action related to the rezoning from residential suburban R2 district to corridor commercial CC district and residential transition R3 district for 1.9630 acres out of Espiritu Santo Grant Share 22 partial tract K1 as allowed under section 2-26 of the Brownsville Code of Ordinances. City Attorney's Office and Planning and Redevelopment Department.
Thank you, Ms. Moore. I appreciate that. Good afternoon, Mayor Commissioners. I'll try to make it as short and sweet as possible. Before you today, we have an item that was considered at the joint meeting between the Planning and Zoning Commission and City Commission on August 3rd of this year. So, oh, that's me, right? There we have the subject property in yellow highlighted. It's on the north side of Altamolor, approximately 140 feet east of Ridgeline Drive. The property owner requested to go to CC Corridor Commercial and R3 Residential Transition, which is what they're proposing. And currently they are R2, which allows single family and duplex use. You can see that that's the current zoning map and it's consistent with the surrounding area. As I mentioned earlier, this was shown before at the joint meeting during city initiated rezoning. And approval at that meeting, and so did Planning and Zoning Commission. I'm available for any questions at this time.
I believe the issue were the trees in the past,
Correct, yes, sir.
and that's been taken care of, correct?
Yes, sir, yes, it has.
24 trees, is that right?
25
25,
additional,
half.
the landscape requirements.
You were double checking the number.
Yes, we have the plan in case the board, the commission wants to see that. But that's going to be taken care of during the building permit process.
And who, as they're building, who checks to make sure that's actually done?
That'll be between the building department along with the, not the landscaper, what's his name?
They're gonna be required.
City forester.
Site plan.
Yes.
Site plan will have to correlate with the approved mitigation plan.
Vote to approve.
Second.
We have a motion and a second. Any discussion? Those in favor?
Aye.
Those opposed? Motion passes. Thank you.
Thank you so much, guys.
Count those 26 feet.
Yeah.
So, thank you.
Item 4, consideration of action to approve a minute order setting February 3rd, 2021 as the inaugural term start date for the Brownsville Ethics Advisory Commission, City Attorney's Office.
Mayor and Commissioners, this item was brought up as we worked through this last EAC meeting. It was brought to our attention that that there was a resignation that had occurred. And so in a process of gathering dates and data, we were informed that there were also some discrepancies in how the positions, the terms were allocated. Currently, all the EAC members have been appointed to serve two years. But as you can see in 38-187, the inaugural board is required to draw straws to determine which 3 members will receive an initial term of 1 year to stagger the terms. Currently, the way it's going to work, if it's not done this way, is that you'll have all the inaugural members having their terms expire within months of each other, which is what this provision tried to anticipate. For whatever reasons, they didn't do it.
Because that's BAU in Brownsville, but not stagger. That's what's been done for years.
Yeah, it's even in the ordinance, and it wasn't done. As soon as I found out about it, I worked with Lori and our team to kind of come up with a way to get this back on track without making any amendments to the ordinance itself. I've used this tool before as a minute order to kind of clarify intents and purposes of the ordinance to get things back on track before. But it's a recommendation. I would take the commission's comments.
I think.
I'm sorry.
Go ahead, Mayor.
I'm looking at the expiration date, council, some of these members already. It looks like there's two, I'm sorry, wait,
No,
there's four whose term currently expired already.
Right,
Yes?
that's correct.
Those then need to be reappointed, or what's the thought there? Because we haven't even looked at that.
Right, right. I mean, I found out about this on the 21st of this past month, and their terms expired. If you take into account that they,
Staggered already then. If we go by the expirations.
well, they're within months, they're within months of each other, but
But we
Okay.
barely appointed them on those days, no?
they had their first inaugural meeting on February 3rd of 2021. And so,
Some of these members didn't even really participate for 2 years. I remember that.
right,
So you're suggesting then that the appointed date, what are you suggesting?
that
Goes back to February 2021.
it goes to February 3rd. My recommendation is back to February 3rd, 2021, because that was the first date they could have acted upon anything. And then that they draw straws at the next meeting to determine which of the three would have expiration dates as of February 2nd, 2022, which is in 3 or 4 months. The remainders would have their 2-year term that would expire February 2nd, 2023.
Council, you need 3 to expire soon, you got?
4.
Yeah.
There's four that are expired. and-
One resigned, and then you have one with 7 absences and one with 4. I think it should be just 5 absences.
Can we just
One of-
clean it
one
up,
of
bring
the
it back at
fours.
the next meeting?
One of the fours resigned.
Yeah, one resigned, but
Okay, hold on. Commissioner Glass.
Can we clean it up and then bring it back at the next meeting? Because as you said, take out the one who's never been here, take out the ones who have the high absences.
Oh, absolutely, yeah. I mean, the appointments are at the discretion of the commission.
And then adopt the change then.
And then it
And then
kinda-
is there a limit as to how many times they can get reappointed?
No,
then it kind of sets up well because the ones with the most are commissioned, the one Commissioner Munguia had and Commissioner.
So am I allowed to make my comment tonight?
No, yours is a separate item. It's coming up. Yeah, yours is good.
So.
Right.
Commissioner Tetra, you're gonna say something?
Oh, I completely forgot.
Okay.
Okay, I just want to make sure, I'm not clear I have the direction from.
Well, you're suggesting that we go back and start this on February 2021, which makes total sense, because that's when the first meeting was, because it was dormant for a long time.
Right.
What we're saying, though, is it's almost like taking care of itself based on a resignation and 2 that have high absences that were appointed by commission members that are no longer here.
Yeah.
So that might eliminate the need to draw straws, but this item is really just about the start date, right?
Correct.
Then we can come back and consider appointing and reappointing.
Yes, absolutely.
Okay.
It's always with them.
All right.
But Commissioner Del Santos, did you have some?
2 things, and this is directed more towards our city manager, who I know is joining us virtually. While this is a good step, this is just one board. This needs to be done across the board for every city board. And I've been preaching that for 5 years, but citizens don't get listened to regularly. Now that I'm a commission, I'm going to reiterate it. This has got to be done across the board. There's too many of our boards have everybody expiring within a few months for each other or the same day. That is unacceptable. With regard to this one, and the reason we have staff is credited for putting this report out for everybody, but I requested this report because I said before we're going to give them another 18 months, especially for some of these whose terms are retired, I wanted to know who's showing up, who's not showing up, especially considering some of the business they've taken up this year. And of course, the District 3 appointment is the one with the worst attendance records. So whether we adopt the minute order tonight or do something different, I know I want to see on the next agenda the opportunity to add or remove members of this board.
That works.
And other boards too, because I got complaints from planning and zoning that they sometimes don't have quorum.
I think what we need to do, and we're coming up on the end of the year, whether we want to wait till the end of the year or do it now, but we need an attendance report for every city board. And we need to look at that. Is it time to start making some changes now so that when appointments come up in December, we've got a clean slate?
Well, I agree with that, Commissioner, but I think because there was appointments coming up very often, we kind of made it twice a year, from what I recall. I think it's June and maybe December, if I'm not mistaken.
Yeah.
But I think that there should be another avenue to address certain things, like where there's quorum issues, where the director can make a request to the commission to be put on the agenda to address that issue and appoint or remove members if necessary, to clean that up because they're having quorum issues.
And I think it's important also, whenever there's a vacancy that comes up, that we be notified right away. So I think there are boards where there's been a vacancy and the department's like, well, we'll get to that next month. We're a little busy right
That
now.
happened with BCSC. That was a vacancy for like 3 months.
Yeah. Mhm.
Okay, so then the item itself is consideration and action to approve a minute order setting February 3rd one as a date.
Second.
We have a motion and a second. Any additional discussion? Those in favor?
Aye.
Aye. Those opposed? Motion passes.
Item 5, consideration and action to approve the 2022 City Commission meeting schedule, Office of the City Secretary.
Lori, I did have a question, and Commissioner Petro and Commissioner Gowan are probably the ones with institutional knowledge on this, but July has 2 meetings. If I recall, July typically would have maybe 1 meeting or no meetings. I don't remember. Whatever it was.
For several years, we had one meeting in July.
I think-
And then it changed.
I think we should do that and just have 1, because August is terrible for some of us because there's budget meetings, there's special meetings all over the place. So I think we should consider just doing maybe 1 in July if the commission's so inclined.
Yes, sir. We had put it that way because we knew that had been the practice in the past, but then this year we actually had a second meeting in July. So I had put in the memo that, we included it, but of course you have as the commission, to amend it to take out the July 19th and have just the first Tuesday in July.
Okay. I would suggest we just do 1 in July, unless somebody has an issue, and the one that, the 5th makes sense, but it's right after 4th of July, so I don't know if that causes an issue.
And that's another thing.
Maybe it should be the 12th? I don't
Does it
know.
have to be a Tuesday? Maybe it can be the 6th.
It's
I have
really up to
no
all of
idea
us, so.
what's gonna go on July 6th.
That might create problems with other boards that are meeting on a Wednesday.
The only thing that happens with us is if there's a city commission on a Tuesday that follows a holiday, whether that holiday fall on Friday or Monday, we have to move our agenda deadline for departments for having their items and their approvals in early. And then we also move their PowerPoint deadlines also as well to accommodate for the holiday.
So you're saying that we should.
But they'll have 11.
Like the July off.
They got plenty of time to see it, they'll know.
Or you could just give us the whole month of July off.
Oh, that's 20.
You could give yourself the day off too. But I think it's a matter of, I think the 19th works. That way we don't have to deal with 4th of July issues.
Okay.
There's an adequate amount of time for folks to go out of town. That's what they want to do. Commissioner Gowan can go travel.
Right.
Gee, thanks for singling me out again.
You took an awesome,
I took it really well the first time. but-
awesome vacation. I'm jealous of your vacation, actually. But yeah, so does the 19th work then for everyone?
I'll move to approve with the correction of July 19th being the only July meeting.
Motion and a second. Any additional discussion? Those in favor? Aye. Those opposed? Motion passes.
Okay, so November, we're gonna have 1 week after the other. And December as well.
Yeah, and it's
Is that
that,
new?
it's that way this year, and I believe it was that way last year as well, to accommodate, I'm assuming,
Holidays.
Big 10 years, I know.
Okay, so we can move on to board appointments. Item 1, consideration and action on resolution number 2021-065 to appoint 1 member to the Ethics Advisory Commission, Office of the City Secretary. So as previously discussed, Rochelle Garza resigned and she was appointed by Commissioner Gowan. So we need to, have a nomination to, appoint a new member.
I would move to appoint Juan Pequeño.
Second.
A motion and a second for Juan Pequeño. Is there any discussion? Those in favor?
Aye.
Those opposed? Motion passes. Thank you.
Okay, and since we're not needing an executive session,
Thank
the
God.
final item is adjournment.
I'll move to adjourn.
We have a motion to adjourn. Is there a second?
Second.
Motion and a second. Any discussion? Those in favor?
Aye.
Those opposed? Stand adjourned. Thank you.
There being no further business to come before the city commission, upon duly made motion, the meeting has adjourned at 7:06 PM. Everyone have a good evening.